I can't hear anybody or anything.
How about now?
I can hear you now.
Okay.
Thank you.
So are you saying you're present?
Yes, I'm present.
Okay, good. All right, first order of business is old business discussion and resolution adopting to elections, action items. So I sent an email to the Coos County Election Board this morning. The email, I asked a question saying, we are having a special meeting tonight to discuss the November 5th election. Has the form for the ballots been sent to the printers? Please advise today if possible.
Point of order, Mr. Mayor.
Yep.
We skipped a few agenda items.
Oh, we did. Okay, excuse me. Are there changes to the agenda? Oh, okay. Approval of the agenda action item, motion to approve the agenda as presented.
I move we approve the agenda as presented.
I second it. All in favor, raise your hand and say aye.
Aye.
All right,
Aye.
citizens' comments. 3 minutes. Do we have any citizens' comments tonight?
There's one on Zoom.
I thought comments were supposed to be received by 4 p.m. Emails if they were, no?
Just
Okay.
at the meeting itself.
Okay.
As long as they fill out the form, I'm good. If it's written, yes, of course, by 4 p.m. Actually, I think it's 12 hours or something.
I don't see anything.
So can the person who wants to make a comment do a little, what is that, hand raise thing or whatever?
Hi, this is Tristan Armstrong. I can't figure out how to raise my hand. I'm joining
That's
remote.
okay. We got you loud and clear. So I believe you would like to make a comment?
Yes, I just wanted to, on behalf of M. Armstrong Construction, rescind our bid for the senior center deck.
Okay.
And the reason for doing so is based on the negligence of the city manager at this time. M. Armstrong Construction, unfortunately, does not feel comfortable and have confidence in the city manager running the city appropriately. So we are rescinding our bid, unfortunately.
Okay, thank you. Any additional comments? All right, on to the next agenda item. Again, it's item number 7, now that we've got it in proper order. Discussion and resolution adoption to elections action item. As I was mentioning earlier, I sent an email to the Coos County Election Board. Hi, Lark. We are having a special meeting tonight to discuss the November 5th election. Has the form for the ballots been sent to the printer? Please advise today if possible. And here's the return message. Good morning, Mark. Thank you for reaching out with your question. The election notice deadline has passed and we are no longer able to make changes to the November 5th, 2024 general election ballot. I hope this helps. So that is what it is. All right, on to discussion of this item. I would like, at this point in time, I'd like to make a motion. Being that it won't be affecting this election, I'd like to make the motion that we take this off. We put this, we close this item and hold it for the new council. This council is only going to be around for a few more months, and I think it would be more appropriate that they decide this. We've got 2 years to do it in, and maybe we could actually, well, I'll remake my motion, but this is the reason maybe we could actually spend some time to do this properly. My motion is that we close this agenda item to discuss a resolution and bring this up with the new council.
Maybe I'm confused because I'm on Zoom, but what was the motion?
We're open for discussion now. So Nikki, would you like to make a statement?
I just, maybe I didn't hear right on Zoom, but I'm confused as to what the motion was exactly.
The motion was to close this agenda item and bring this agenda item up in the new council.
If it's pertinent to the election now, how could we close it and make it up to the new council?
So you believe it's pertinent is what you're saying at this point?
Well, I thought the whole situation was discussing whether a lane could be moved to the 2-year versus the 4-year. I thought that's what the whole discussion was about.
Okay, anybody else want to make comments?
Well, we got to just kind of move now. There's ballots are printed.
I can't, Alan, I can't hear you.
So Gary, could you pipe in on where this president election stands? I'm sorry, Gary, could you hear me?
Are you referring to me?
Yes, I'm sorry. Mr. Gardell, could you please enlighten the members of the council where this present election stands?
Well, my understanding is that the municipal code outlines the procedures for putting your name on the ballot. It doesn't specify that the city needs to identify districts. In this case, and correct me if I'm wrong, we have 4 positions, but 3 of them are for 4 years. 1 is for 2 years. Nobody specified what they wanted on their filing, but subsequently, one of the candidates said she would be willing to do the 2-year term. So I guess about the only option is for the city to accept that declaration, and the other 3 will be sitting for a 4-year term, and that 1 candidate will be sitting for a 2-year term. The procedures aren't addressed specifically enough in the code or elsewhere. So I think it's a matter of council interpretation. And at this juncture, I think it's too late to really do anything other than accept what the candidate's wishes are.
Okay. Would any of the counselors like to make another statement? Adam Mann?
I definitely have some concerns in regards to how the elections are going. Giving the note that Mark just read from the county, it seems as if we don't have any way of changing it at this point. I do look forward to a discussion in the future. The last gentleman who spoke did say that, please correct him if he was wrong. One point I did hear was that none of the candidates declared a particular position. And in my review of the county's documents on that, several of the candidates did indicate what position, and then a couple of them did not. So just for the record, there were some candidates who indicated specific seats.
Is there any further discussion? Okay, I move to close discussion. The motion that stands before us is to close this agenda item and bring it up in the next council. All in favor, raise your hand and say aye.
Aye.
All opposed, raise your hand and say no.
Sorry, I was late.
So to clarify, let's go ahead and do the count again. All in favor, please raise your hand and say aye.
Aye.
All against, raise your hand and say no. Okay. Agenda item closed. The next item is the Rainbow Property Contract. Okay. So we did have a question in regards to this contract, and we could not accept it in our last meeting, so we're bringing it up again. And the issue involved the council's request was to not have the lien removed. There was some discussion as to what would actually happen with the lien and what type of safeguards the city would have. At this point, Mr. Darnell, can you clarify the contract in regards to the lien on the property?
I hope so. And initially, as you remember, I recommended
Just a second, Gary. They're gonna try to turn up the volume because we're having technical difficulties. Sorry about that. Okay.
Let's try that.
if you'll remember,
Perfect, great, you can hear me.
if you remember initially, my concern was that the city needed to protect itself as best it could. And that I didn't want the city to discharge the liens until the cleanup had been completed. Apparently the purchase needs to occur in a much more expeditious time frame. So the only way that I could think of to protect the city was to have a contract between the city and the property purchaser where section 1 of the agreement essentially says, okay, in exchange for discharging these liens, you have to do the following. And basically she has to clean up the property within 90 days to the satisfaction of the city. And then there was also a provision where the city would try to claw back some of its administrative expenses, which it has spent over the last 4 years with the current property owner. Now, I know records aren't very precise. Some of the records, such as the city attorney's billings, are precise in terms of how much time I've spent on this issue. So you can certainly factor in that. The important thing is the city should probably get back what funds it can document and just let the rest go. My understanding is the most important factor is that the property be cleaned up.
Correct. And presently, there is a lien on the property to ensure that it gets cleaned up. And then I believe this lien is reapplied with this contract. It's taken off and then reapplied with the contract. Am I understanding that correctly?
Well, the contract is to replace the situation where the lien would be discharged before the purchase. This way, the city has the ability of the contract to enforce the cleanup.
And how does the city have the ability to enforce the cleanup?
Well, they would have to go to court and get a judgment.
On a lien, or do we go
No.
through the whole process of code?
It's what you're doing is you're enforcing the agreement, and the agreement is in return for the discharge of the liens, the new property owner will clean up the property in 90 days, and then whatever amount the contract says she's supposed to pay, she will pay the city.
Question, did you guys get a new contract? Because the one that's in front of me says the same thing as it did on Thursday.
Correct.
You did?
No, we didn't. Same one. So I guess maybe I'm not understanding this is let's say the buyer does not meet her obligations in the contract. What happens? Sorry, Mr.
I'm sorry, was that a question?
Yes, that was a question. So if the buyer does not meet the terms of the contract, at that point, what happens?
Then we go to court and ask the court to give us a judgment, forcing the defendant, in that case, to clean up the property and pay us the money. Not the liens, but the money that the contract lists for administrative costs. Now, my copy of the contract doesn't have a dollar figure entered into it. Yeah, I left it blank for the city to fill it in.
Right, right.
Can we open it up for discussion?
We're in discussion right now, yes.
Okay, so under agreements, under clause 3, it says the same thing as it did on Thursday. After the city has been compensated by Ms. Fleming for its administrative and legal costs associated with the nuisance enforcement against 245 Rainbow Lane, Lakeside, and in the execution of this agreement, and after the nuisance conditions at this location have been abated, the satisfaction of the city shall discharge the 2 liens. And she stated at the meeting on Thursday that cannot happen. The liens have to be discharged before she cleans the property.
Right. That's not the version of the contract that I gave the city.
Okay, well, if anyone else has a different contract in front of them, please let me know, because me as a city council member, this is the version of the contract I have in front of me.
That's what I have in front of me as well.
Yeah, I also.
I believe the question at the last meeting was, correct me if I'm wrong, the question that we asked to be sent over to the lawyer was whether or not the sale was dependent on removing the liens.
Originally, it was, and the first draft of the agreement stated that, and apparently that's the draft you're looking at now. We were told by the title company that they can't accept that. And so I told Krista that the only other option was to have a contract where we bound the new purchaser to basically clean up the property. We would discharge the lien first, but she would have to sign this agreement before we do so.
Sir, may I ask you a question?
Sure.
I brought this to the attention of Krista on Friday, and she said she emailed you on Monday my question. When did you forward this contract to the council and the city manager?
I forwarded this form of the agreement to Krista over a week ago. And what the conversations we had after that were limited to documenting how much administrative expenses she could identify.
So in front of us today is a document that is over a week old, that is not pertinent to the meeting today.
That's correct, apparently.
So
Okay.
the person who's purchasing the Rainbow Lane property is in a very tight time crunch. And we do not have the proper contract in front of us today to make a proper decision.
Well, you can authorize the mayor to sign a contract if you know the substantive provisions. And I can read to you the provisions that are most applicable, if you wish.
I'd prefer to have it in front of me. I'd
Excuse
prefer to
me,
review it. If we call a special meeting tomorrow, I'd be okay with that. I'd prefer to review it.
you're out of order. You were not recognized by the mayor. I was going to address Mr. Darnell. Mr. Darnell, could you read the substantive portions of the contract so we can move on this issue? The substantive changes. I'm sorry, Mr. Darnell, did you hear my,
No, what are you asking?
like you were mentioning before, could you let the council know the substantive changes to the contract?
Okay. I'll read you the first three provisions that are the major change. The first section under the agreements reads, in exchange for the city's discharge of lien numbers 220-01887 and 2019-10621, Ms. Fleming agrees to the following. A, the nuisance conditions of 245 Rainbow Lane, Lakeside, Oregon, shall be abated to the satisfaction of the city within 90 days of the finalization of the purchase of that property. B, nuisance conditions of 245 Rainbow Lane, Lakeside, Oregon are not abated to the satisfaction of the city within 90 days of the finalization of the purchase of 245 Rainbow Lane, Ms. Fleming agrees to personally owe the city the amount of the two liens plus interest. The city may secure this debt by reestablishing a lien in the amount of aforementioned liens against the property. Section 3, that should be section 2. Ms. Fleming also agrees to compensate the city of Lakeside, Oregon for its administrative and legal costs associated with bringing 245 Rainbow Lane into compliance with the city of Lakeside's nuisance regulations and in executing this agreement. As of the date of this agreement, the city estimates that it has expended blank in legal and administrative costs associated with this compliance action. Those are the substantive changes. So instead of just charging the liens prior to the purchase, now they'll be discharged. Well, they'll be discharged prior to the purchase, and the contract will ensure that the city gets the property cleaned up or get compensated.
Thank you, Mr. Darnell. I recognize Councilor Wood.
Excuse me?
Oh, I'm recognizing Councilor Wood.
Oh,
Well, I didn't have comment, but I was in turn before because we were open to discussion. I just want to clarify that, have you reviewed this with Miss Fleming? And she's all right with these terms?
I have no idea.
We have not reviewed this, obviously. She's on the speaker at this point. I believe at this point, I'm going to go ahead and make a motion now that we have the particulars of this, and this is a matter we can discuss amongst the council as to what we want to do. The motion would be based upon what we've heard the substantive changes to the contract are, and without the ability to actually see the contract in front of us, are you going to authorize the mayor to sign this contract if all parties agree upon it? That's the motion before us. Is there a second?
Is it open to discussion now?
We need a second.
Could you restate your motion as an affirmative rather than as a question?
Okay. I make a motion that the council signs, agrees that the mayor can sign the contract based upon Mr. Darnell's reading of the substantive changes to the contract. Do I have a second?
I'll second that.
Okay, we're now open for discussion.
I just want to make it, I believe I heard it correct that Mr. Darnell said that we would have the right to reinstate the liens if the property is not cleaned up within 90 days of purchase.
Correct. Mr. Darnell, could you answer that
That's
question?
correct.
Thank you.
I have a question.
Councilor Hand?
Is it possible to have that 2-page contract emailed to us so that we can look at it in the next few minutes?
If I have an email to send it to somebody, I can do that right now.
You can send it to me and I'll go get it.
I have a question.
Councilor Wood?
The blank for administrative costs, have we determined what that would be?
We discussed in the last meeting 5,000. I'm assuming that remains.
Is that okayed by the attorney at this point?
Gary, I believe Counselor Wood was asking if the $5,000 was okay with you.
Well, I have no idea what the administrative costs are. From the city standpoint, I would have to go through the different invoices that we've sent you over the past 3 or 4 years to determine what my charges have been.
I do feel as though I 100% support Miss Fleming. I do agree with everything she's doing, but I do feel as though over the past 3, 4, 5 years that this has been going on, the city has spent more than $5,000 on administrative costs on this. And I would feel more comfortable if maybe the attorney had reviewed maybe some of the invoices, maybe we have a better number going forward. That's just my opinion.
Well, I don't disagree with that.
I have a question that's in a different direction. Mr. Darnell, if we were to enter into this agreement, the one you read to us, in the event that the current property owner, having been relieved of the burden of the liens, then went forward and sold the property to another party at a higher price, would we then have any recourse?
Well, we would always have Mrs. Fleming on the hook.
Yeah.
Can we move this agenda item to later if we have a copy of the agreement in front of us to review?
Excuse me, Counselor Wood, Counselor Hand had asked to be recognized.
Sorry, it's hard on Zoom to know what's going on.
Well, I'll direct traffic.
I feel like I can agree with what Nikki was saying, that I absolutely support what Amanda is trying to accomplish here. And I feel like the city should be trying our very best to help her achieve that. That said, we should at least find out if our legal fees are going to be more than that $5,000 number before we just obligatorily stick a number in there.
Okay, I sent a copy of the contract to the city just a second ago. It probably will take me at least a day to retrieve all those invoices. That's why I asked the city to do that, because I assumed that your records were maybe more accessible.
Do we have those records?
So I believe Counselor Wood is recognized now because she had made a. Right, Nikki? You were up next for comments.
Yes, Mayor, thank you. I was asking maybe if we could move this agenda item to a lower agenda item so we can have time to review the document in front of us.
Would you like to make a motion?
I'm on Zoom and Amanda says she has a few things to say. Would you guys like to recognize that?
Yes, I think we can have comments from Amanda. Please go ahead, Amanda.
Hi, can you hear me?
I sure can.
Okay. So, Krista, is she there?
She's getting us the contract right now.
Okay, I just can't see in there very well. I can't see who's participating. I'm sorry, and I was a little late logging in. I thought Krista told me the CPA had gone through and had done an accounting of what the city owed. That was the first step to even start the contract. And that was the given number that I was already given so we could move forward. And so I'm a little not understanding why now we're saying we don't know what that cost was. And also when I was working with the last city attorney, we have an email stating the attorney fees were 500, and then we were told 1,000, and now it's up to 5,000, and we've agreed to all that. So I'm just wondering why it would go up again if we already did an accounting.
We have the same attorney.
Maybe Chris is now in the room, maybe we can ask her that question.
Thank you.
Thank you, Kristen.
Krista, there was a question for you in regards to the other non-attorney fees. Somebody was saying that the CPA had looked at those fees.
The CPA did look at the fees. However, the CPA that we have now was not tracking those as a case. There was some accounting prior to her becoming our CPA based off the estimated staff time that was put in, from what I could tell, attorney's fees, and what we could account for, that would be an appropriate amount. I don't know what happened prior to what Ms. Fleming is saying, 1,000 and 500 and things. I don't know.
Yeah, I don't know about those yet. Okay, so that's what information we have, Amanda, in regards to that.
Can I speak again?
Sure.
Oh, those previous numbers were from Rick, the previous city manager, when I was first trying to purchase the property last fall. And then when we moved into this spring before he and Krista traded places. That's where those numbers came from. However, the city said 5,000 now, and I was totally cool with that. I just, I trying to conduct a business, so it's hard for me to conduct a business if we're going to keep changing the numbers. Does that make sense?
Yes.
Okay. And then also I want to know about the second amendment in there said something about the liens being personally applied to me. Is that what I understood correctly?
The liens will be applied. Yeah, I'm sorry, Gary. Please explain. Gary Darnell, please explain to Amanda. Could you answer her question?
Yes, the section 1B says she agrees to personally owe the city the amount of the 2 liens plus interest if she doesn't comply with the 90 days cleanup.
Okay, and so that's in order for you to drop the lien once title closes and I own the property, correct?
Correct.
Okay. Because if the title doesn't close and we get to the point like here in, 2 weeks that we don't get all this figured out, and we're doing this, I don't want to be personally responsible for a property I never got to own.
Right.
Okay. Because, I don't want to sign I would like all of this to go through title. So, if we're going to do another special meeting and add an amendment, I would like the city of Lakeside to receive the money that they want once we can figure out what that amount is and we agree on it. And all the lien process to go through the title company. I've already started title with Tycor. Would that be okay?
I think so. I guess
Because I don't want any legal stipulations put on me personally until the title closes and I have my title insurance that the title is clean, so I can move forward to clean it up and fulfill my obligations of the new contract with you guys.
Right. I think
Thank
the
you.
city's interest is not to discharge the lien until we're absolutely sure that the purchase is going to go through.
Thank you.
Okay.
And the city will be paid through title. Because title has requested the payoff amounts of the two liens, and we could send them the payoff of what the two liens are, of the amount we agree. And then they can send you the checks for those.
So, I'm sorry, I'm not quite sure what your question was, Amanda.
The question was just to make sure that you guys will be paid through the title company when the purchase is complete and not through me. I mean, I'm going to give them the money, of course, but I want them to be a third party involved in our transaction and these liens.
I'm not
That-
sure what.
That's
Oh, I'm
gonna
sorry.
re- that's
I
gonna
think the
require-
attorney does.
That's going to require a change in the agreement if we're
I
going to add a
understand that.
third party.
I understand that, but because I don't want to sign a contract with you and write you a $5,000, $10,000 check if I don't close.
Right.
I need to safeguard myself. How do I safeguard myself in this contract? And now I'm personally agreeing to clean a property that I may or may not close on. So it would be best to have this transaction with the city and I take place through the title company. Wouldn't you think? That way we have proof that the city was paid the amount of the obligations that they are asking for?
Have you talked to the title company about that option?
I have, and they are willing to do that. They said all you would need to do, and Krista has the paperwork from the title company. They sent in for lien release probably about 2 weeks ago. And what the amounts would be if those liens would be released. And that's where we would put the owed amount to the city of Lakeside. And then during title and close, Ticor Title would cut the city of Lakeside that check to clear that. And that would be your guarantee of the payment. And then from there, in title, I can either sign a notarized paper there for your contract, or I can come in to the city when we're closing, or the city can send the contract to title and I can sign it with title when I close for the obligations of the cleanup for the 90 days.
Okay, I'd like to see that paperwork from the title company.
Krista has all that. It was emailed to her, and then there was a new title report just done today through them, because we actually have a few other pending liens that popped up that we're trying to clear here also that don't even involve the city. And I believed that the title company sent it the first one to her a couple weeks ago.
May I speak, please?
Recognize Councilor Wood.
From the beginning, I'm just wondering why the pertinent parties weren't involved in a conversation one-on-one to streamline this process, because I feel like a lot of the whole back and forth would have been avoided if everyone could have communicated better. Just thought.
And any further discussion?
Yeah, talking to the lawyer, how long would it take to get the numbers together for the city to actually make a correct bid when it comes to the estimate that she owes the city?
That question was for you, Mr. Ernell.
Is that directed at me?
Yes,
Well, it would take me at least a day to go back through our files and pull out all the charges that I indicated were in regard to this situation. It's a little murky because years ago, one of the things that I was asked to do was to change some of the nuisance procedures to make it easier to, and probably more legally substantial to move forward with the citations for the property. So some of this stuff is going to be a little much in the gray area where we had to do other things in order to move forward on attaching liens to this property. I like the idea of just taking a guesstimate that you know is going to cover at the very least your administrative costs and going with that if Ms. Fleming is supportive of that.
and that can be discussed later since well, I'm thinking maybe since we do need to redo the contract to protect Ms. Fleming in regards to the pulling it out of title, that maybe those issues can be resolved when we have the new contract. My thoughts?
I would need to talk to the title company's attorney.
Gotcha.
I need to see the paperwork that they proposed.
Okay, so is there any further discussion in this matter? So the motion that is before us at this point in time is simply a motion to accept Gary's verbal substantive changes to the contract and allow me to sign for that. And that's up for a vote. All those in favor, say aye. All those opposed, raise your hand and say no.
No.
Okay. And I believe since we're still on this topic, we can make a new motion. Would somebody like to make a new motion in regards to this contract? If we don't make a motion, then the whole, this whole contract dies.
I think I can try to make a reasonable motion here. The lawyer has told us that it'd take him at least a day to get together his numbers. We've also heard here today that a third version of this contract may be necessary. Given those two facts, I move that we direct our legal help to put together a third version of the contract that includes a solid number on his billing and also protects Ms. Fleming the way that we discussed.
I second that.
I'll now open it up for discussion. Would any of the counselors like to make a statement?
I'd like to speak.
Go ahead, Counselor Wood.
I, again, 100% support Amanda's wanting to clean this property up. We've been wanting this to happen for a long time, and we are working towards it. And I'm very, very upset to see that this could not be resolved tonight. But again, I cannot go forward without knowing that the city will be protected 100%. That's just all I have to say on the matter.
Is there any further discussion?
Can I say something?
Sure, why not?
I was just gonna say, I agree with Nikki. I think the city should be protected. I actually think everyone in the transaction should be protected, and that's why I suggested the third party with Ticor. So, it would be nice to go ahead and just make sure everyone in this is taken care of, so we all can move forward in a healthy fashion.
Absolutely.
All right, was that any further statements from those? Okay, at this point, I'll go ahead and close the discussion. Could you repeat your motion again?
I move that we direct the city's legal counsel to create a third version of this contract that A, gives us a solid number on the legal billing regarding this issue, and B, protects Ms. Fleming with the title process that we discussed here today.
All in favor, say aye and raise your hand.
Aye.
We get a second on that?
Oh, I'm sorry, we didn't. Yeah, we did, because the motion is, we're repeating the motion for the vote. So we did. So, all opposed, raise your hand and say no. Okay. That is that agenda item. Thank you, everybody, for their patience. The next one is the hearings officer's contract. We had some questions about the contract. Do we want to go on?
I had a question regarding this. It was my understanding that we had a 6-to-1 vote to approve this contract at the last meeting. And I'm confused as to why it's here in front of us again.
Did we approve this?
It certainly is.
Okay. I didn't think we did either. I didn't sign it.
I mean, I specifically voted no and explained myself, and
Yeah, that's what I remember also.
You voted no for the contract? Oh, but you were telling me, okay.
it was 6-to-1,
Yes.
myself being the one.
Yep.
The 6 would have approved. My request. I mean, what we have in front of us is no different than what we looked at.
Mayor.
Well, there were questions about waiver.
And I have, I mean, if we want to discuss it, I brought the details that I didn't have last time.
I recognize Council Ward.
My recollection, which could be faulty, was that we had tabled this item until tonight, simply in order to get clarification on whether or not the contract contained or requires waivers to the contractor's right that are discussed in municipal code section 32.02 G2.
That was my understanding too.
That was the point that I brought up, but we, in the end, voted. I'm more than happy to discuss that point, though.
Well, let's continue on with the discussion of waivers until we determine what the vote was last time.
So, Mayor,
Please.
at the last meeting, the question that I brought forth was the lack of sections in the agreement that are described in website code 3202 G2. And I'll read that right now. Unless otherwise approved by the city recorder manager, all personal service contracts shall require the contractor to defend, indemnify, and hold harmless the city, its officers, agents, and employees against and from any and all claims or demands or damages of any kind arising out of or connected in any way with the contractor's performance thereunder, and shall include a waiver of contractor's rights to ORS 30.285 and ORS 30.287, indemnification and defense. I still don't see any waivers relating to those ORSs in this contract.
Councilor Ward, would you like to recognize?
Yes, actually, if we look at the first words in municipal code section 32.02G2, they are unless otherwise approved by the city recorder manager, which I take to mean that if the city recorder manager elects to waive the requirements described in the section, they can.
Is that the case?
So I'd like to pose that question to Mr. Darnell. Could you repeat the question, Ron? Or could you format a question to our lawyer about your reading of that?
All right, so Mr. Darnell, we have a section of code that sets requirements on personal service contracts. And the code section begins with the words, unless otherwise approved by the city recorder manager, all service contracts shall require. So my question is, if the city manager elects not to require the items that are listed further on in that subsection, is the contract permissible without those elements?
The code, that code section you referred to, if my recollection is correct, just refers to the insurance amount. Is that correct?
It refers to defend, indemnify, and hold harmless the
Oh,
city.
right.
And
And that's why the indemnification clause is in here. The reason
Yes.
I think this contract is going to you is that you can give direction to the city manager as whether or not they should or should not require indemnification. It's pretty standard. The contract requires that the independent contractor, Mr. Milliman, has his own insurance that's equal to your tort coverage. And of course, you're covered as well. So essentially, you're having the two insurance companies indemnify themselves.
Right, but what our code's asking for is it's asking for the contractor to indemnify the city and to additionally obtain from the contractor a waiver of their own rights to be indemnified.
Right.
So we're wondering if the city manager has the authority to waive the requirement for a waiver.
Well, the code gives the city manager that power. However, I think you can override that in your direction to the city manager. In the way that this agreement is written, it's not waived.
Correct.
And I don't know if Mr. Milliman has seen this version of the contract and agrees with what it says.
I believe this was his contract
He signed it.
and he signed it, so. So yes, Mr. Darnell, Mr. Millen has seen this contract and has actually signed it.
So it seems to me that the decision as to whether or not those waivers need to be in the contract is up to the city manager or recorder as described by Councilor Ward. So the question, I think, goes to the city manager. Is it your intention to waive the waivers?
Waive the waivers.
I mean, I understand that it's a little confusing, but that's what our code says. It says unless otherwise approved by the city recorder and manager.
Unless otherwise approved. Right?
Yeah, so we're asking, did you approve? Do you wish for this contract to go forward without the waiver?
I think that's a legal question, correct? Isn't that?
You have the right to simply say that the waivers don't apply. As city manager, you can direct the council to say the contract as it is okay.
What does Mr. Darnell suggest in this?
Well,
What does legal counsel say? Because that's a little confusing.
the code gives the city manager the right to waive the requirements for insurance. Is that what it reads? I don't have it in front of me. She has chosen not to require that waiver, so he has to carry insurance. I don't understand what the issue is. Apparently, it's not a problem with him if he signed the contract.
Mr. Mayor, so,
Mr.
so I understand that as of now, it states that he must carry insurance.
No, that's the indemnification clause, is that.
Yeah, I think the insurance is a different section, maybe section 3, G3. What we're discussing is G2, which is specific to some waivers.
Item 10 says that the contractor shall obtain and maintain liability insurance coverage in at least the amount of the city's tort liability limits, naming the city as additional named insured during the life of the agreement.
And my question has nothing to do with insurance. That's what I'm saying. Number G2 doesn't say anything. It's not about insurance.
Well, before this gets too long into the weeds, we were discussing the contract in regards to waivers. Mr. Ward says that the city manager has the option to not require waivers. And these waivers do what?
From my understanding and reading of ORS 30.285 and .287, which I have partially printed here.
Actually, you know what, this would be a good question for Mr. Darnell. What do the waivers do in plain English?
Okay, if the city manager issued a waiver on this contract, that means Mr. Milliman would not have to carry insurance.
That's not what. Would it be helpful if I read the title of each of those sections for us here?
Yes.
ORS 30.285. The title says, Section 30.285, public body shall indemnify public officers procedure for requesting counsel, extent to the duty of state obligations for judgment and attorney fees. .287 says counsel for a public officer when public funds not to be paid in settlement affect on liability limits defense by insurers. My understanding is that within state law and these ORSs, the city somehow becomes responsible for actions of the contractor and vice versa, that we will take care of ourselves in that situation. What our city code says is that any of the contract would have a waiver to these two ORSs, removing those protections for the contractor.
Can you clarify, Mr. Iredell?
I guess I don't understand the argument at all.
Yeah,
The code requires a personal service contract, the contractor to defend and hold harmless the city unless waived. Is that how you read that? And you're saying that conflicts with ORS?
I don't think that's what I'm saying. I'm saying that.
I don't understand what you're saying.
okay, Counselor, go ahead.
From my understanding, what 3202 G2 says is that the state has ORSs in place to protect the contractor, and that our code requires waivers for those protections. It has nothing to do with insurance. That would be section 3. Section 2 specifically, and I'm here nor there on it, but it's just a simple, it says shall include a waiver. And when it says shall include a waiver and there's no waiver, I figured we should discuss it. I agree with what Councilor Ward is saying, that according to that section, it says that the city manager has the right to approve without the waivers. And that's where I earlier placed the question to the city manager, is that her intention?
I don't know who's supposed to answer. From a risk mitigation perspective, I don't think that I would ask that we hold him harmless in the cases of neglect or negligence. And so I would say if he does have his own insurance, that in that case, we may offer a waiver, but that doesn't preclude other charges of negligence. So.
So are you saying we need a waiver or we don't?
I'm saying that it's good practice to protect ourselves, and I wouldn't ask for a waiver.
So you're saying that you would not ask for a waiver?
No.
So okay, go ahead.
And please correct me if I'm wrong, but section 2, once again, I don't believe adds protections to the contractor. It goes further to protect the city. If we have those waivers in place, the city has additional protections, not less protections.
A waiver? Oh.
Councilor Ward.
My reading of the code and statute together is that the statute affords the contractor indemnification by the city, and the code is requiring us to ask him to sign away his rights to indemnification under state law unless you approve letting him keep those rights. And I can't imagine that we would ever get a hearings officer to contract with us if we required him to give up his indemnification.
Exactly.
And those indemnification rights don't apply if there's malfeasance.
This is why I was asking for the attorney's advice on, I'm reading this as well. And so,
Okay, so.
being that he has his own insurance, but it also, that's an attorney question.
Okay, Gary, Mr. Darnell, you heard Rob's explanation. Do you agree with that?
I'm sorry, I couldn't hear you.
So did you hear Rob's explanation of waivers, and do you agree with that?
Yeah, I guess I need to look at the ORS statutes, but the bottom line is we want the contractor to hold the city harmless.
Which is why you have the indemnification.
Right.
So I think we're going in a circle here, and this could be very easily resolved to go ahead with the contract as is.
If you want, I can get back to the council with something in writing that addresses this issue.
So at this point in time, by the way, Krista, did you ever find the count or the contract from last council meeting? The vote count?
Oh. Sorry, I thought since we were having a discussion, we were half.
Well, I'm about ready to make a motion, so.
Well, we went out of order, so if we want to hold on a second, or you can continue with your motion.
So I'm going to go ahead and make a motion that we approve this contract. We're now open for discussion from councilors. This might be a.
Did we get a
Oh.
second?
Yes, we did.
Okay, sorry, I didn't hear it.
This might be a second vote on the same measure, but let's go ahead and vote. All in favor, raise your hand and say aye. Aye. All opposed, raise your hand and say no.
No.
We have 2 noes from Councilor Wood and Councilor Hand. Motion passes. You can get back to us on that one, Krista. It's fine.
Okay.
We've repassed the motion twice if we had.
Okay.
I'm sure that's okay, right, Gary, to do a motion twice?
No.
Okay, so the next one is the fencing contract, and we had some questions about that. We were missing the first page.
Yeah.
Has everybody had an opportunity to look at the first page of the contract? Okay, I make a motion to approve the fencing contract for repairing the fence at the wastewater plant. Mr. Ward?
We don't have the contract in front of us. We have 2 estimates. So we'll use those 2.
Award, excuse me. I reset my motion. There was never a second, so. So the correct motion would be to, would Mr. Ward like to make the motion?
I'd like to make a motion to award a contract for fencing repair to the West Coast Fencing.
I'll second that.
All in favor, raise your hand and say aye. Okay, open for discussion. Go ahead, Councilor Ham, you're recognized.
I appreciate the opportunity to look at page 1 of this contract. That is very helpful. I did have a couple thoughts when looking at page one. At the very, very last line on page one, says that this estimate is good for 15 days from the top of the page, and that was months ago. So potentially, we need to communicate with West Coast Fencing to make sure this contract or this estimate is still accurate. And the second thing I will bring up is same thing that was brought up at the last meeting, is the question on the very last line of page 2, which says that quantity 1 hour at $1,600, that's $1,600 an hour for administrative and overhead costs. And it's not that I feel like that would necessarily stop us from moving forward, but it's worth a question if we're gonna be responsible in approving the contract.
I recognize myself. A contract, what we're looking at is the bottom line and the work done. I think this is way overkill in regards to this contract. My personal opinion.
May I speak?
Councilor Ward raised his hand, you'll be next, Nikki.
Got it.
I'd just like to remind the councilors that it's my understanding that this work is going to be paid for eventually on an insurance claim. Not a budget impacting item.
Okay, Councilor Wood.
Did we just take a vote on a motion before we discussed it?
We haven't taken a vote yet.
What was the vote previous to the discussion?
That
Everyone
was
raised their hand and said aye to something?
the fencing, no, that was the hearing contract. Yeah, so we're on this one now. Fencing contract, do you have any comments?
No.
All right. Mr. Ward, can you repeat the motion in front of the council?
Give it a go. My motion was to award a contract to West Coast Fencing for the repair of our fence.
And I second it.
Yeah, and this is for the vote. So Mr. Ward restated the motion. All in favor, raise your hand and say aye.
Aye.
All opposed, say no. Motion passes. Okay, now it's the decking contract from the senior center. Krista, could you fill us in on what this contract is about?
It's an estimate.
Estimate.
It's to replace the decking around the senior center where they receive food for the food bank. So there's heavy items and it is not stable enough for the weight.
Okay, and how many bids did we receive on this?
We received 2, not trying to get people out. We just had a difficult time getting people to come out, same with the fencing.
Yeah. So how many people were contacted?
There was 4.
4 people contacted, 2 submitted bids, 1 withdrew.
Correct.
Okay, would somebody like to make a motion, then we can discuss it?
I'd like to make a motion to award a contract for repair of the entryway to the senior center to Gold Star Construction.
Second. Okay, we're open for discussion.
Mr. Mayor, may I please?
Yes, go ahead, Nikki.
2 things. 1, I wish to recuse myself from the conversation to avoid anything. Second of all, I would like to remind you of the public comment spoken earlier today. And I will mute myself and I will take myself away from the conversation.
Okay. Counselor Wood has removed herself from the vote, even though motion has already been made. The motion still is out there. Any further discussion?
I have a couple thoughts, of course. First thought is whether or not this expenditure is within our budget means. The second thought is at the bottom of this contract, it says senior center is responsible for obtaining costs of any permit to the project. Do we have any estimates of what that additional cost might be before we go forward? And my third thought is it really responsible to move forward with only one estimate?
And those questions are directed at who?
Whoever might have an answer.
So, Krista, what was the first question?
The first question is about it, whether or not the $11,500 project plus permits is within the current budget means.
So, Krista, is that within the budget?
It is within the budget, and I will point out that there has been a lot of neglect on this building. Regular building schedules are being implemented on all of our buildings to avoid.
And my understanding is this is actually a safety issue.
It is a safety issue.
Okay, second question now.
It's also an ADA compliant issue.
And it's an ADA compliance issue.
I think we all understand the building is in desperate need of some work. My second question is about the cost of permits. Do we have any idea what the cost of permits would be on top of the number we see here on the estimate?
If there are city permits, we charge $50.
Oh, they're city permits, so.
Is that no, I don't know enough about, are there other permits other than the city? No?
I don't,
Okay.
Replacement.
I don't think you even need one for that.
I can accept that. And then the third question was whether or not it's appropriate to move forward, given that we really only have one estimate at this time.
And that's a discussion amongst council.
So that's what we're doing here.
So we've had, excuse me, Mr. Mayor, so we've had 4 companies actually bid on this, correct? Or
We informal solicitation. So we had 2 people come out, people that we have called that said, sorry, it's too small or too busy, those kinds of things. So we can only get people that are willing to do the job.
And that's just how it works around here. I mean, when it comes to plumbing, when it comes to doing this or anything, trying to get somebody out here to actually do the job and write up a bid.
Right, and we did get 2 bids.
One was rescinded.
Still 2 bids.
And I agree, that's the way it is out here.
Yeah.
You just do not get dozens of bids, and it doesn't happen.
Right. Okay, do we have further discussion?
I'll say I'm perfectly willing, if the council doesn't see it as a problem, I'm in support of getting it fixed.
Okay, so the motion in front of us is to award a bid for, who made the motion? Rob, could you repeat the motion? This is for the vote, this is not the second.
The motion was to award a contract for repair to the entryway of the senior center to Gold Star Construction.
Okay, all in favor, raise your hand and say aye.
Aye.
All opposed, raise your hand and say no. Okay, Can somebody signal to Nikki that she can come back on? Okay, we're at council comments. Councilor Pointer, we'll start with you.
Well, we got some things done and we raised more questions probably than we answered, but I thought it was a decent enough meeting.
Councilor Ward?
I have previously commented in public meetings about the lack of appropriate staffing and appropriate trained staff in City Hall. The Mayor has previously noted for all of us the exceptionally high rate of turnover in staffing in City Hall. These two things are related. The city government of Lakeside will never be able to achieve minimal competency unless and until staff are adequately resourced to perform the duties they've been charged with. The city and citizens of Lakeside should consider it normal and expected for their city government to fail to adequately serve their needs, as long as the citizens of Lakeside continue to fail to insist on adequate staffing and necessary training. While I can never know what is in another person's mind, others wiser than I have stated that the best way to know another person's intentions are through their actions. And there's a small group of persons from Lakeside and the surrounding areas whose actions suggest that they would like to see Lakeside city government continue to fail. One of the ways that the effort to halt efforts towards improved city function is shown is through consistent and repetitive efforts to divert city staff from completing work. There are a number of persons, including Lakeside public officials, who frequently make demands of city staff to produce information and materials to serve their personal interests or agenda, and demand that staff prepare presentations and initiatives for public bodies relating to those personal interests. It is in the public interest that the council be available to the citizens and that the citizens be fully able to bring their concerns to light to the assembled council. However, when the demands for attention and action come repeatedly from the same small body of persons, it becomes disruptive of the public's business, achieved through abuse of both the city staff and the established process for being heard. Coming to know this group of persons through their actions, it is at this time my personal opinion that the disruption is intentional. The group of persons, which is the subject of my comment tonight, includes 2 members of this council. As it is my opinion that their conduct is in violation of the current rules of the council, I would like to read from several of the rules that members of the Lakeside City Council are required to follow. 6.3.10. Do not attempt to change or interfere with the operation and practices of any city department. Desired changes are coordinated with the city recorder manager after council discussion and direction. Councilors shall at all times refrain from action that would undermine the administrative authority of the city recorder manager or city staff. 2 members in question frequently and routinely seek to interfere with or amend city operations and practices without council discussion and direction. In this way, they have interfered with the operation of the city staff without the required council discussion and direction, at times successfully hijacking the priorities of the council and replacing it with their personal agenda. Rule 6.3.15. If a councilor wishes to request information or assistance from city staff, the request must be directed to the city recorder manager. The city recorder manager may assign the matter to the appropriate staff if it is determined the request will require 30 or fewer minutes of staff time. A request that requires more than 15 minutes of staff time must first be approved by the council as a whole. The 2 members in question have repeatedly sought to task city staff with work requiring more than 15 minutes without approval of the council as a whole. Our current and immediately previous city managers were likely unaware of this rule and have indulged their demands at the expense of the interests of the citizens of Lakeside. When the mayor read this rule during our meeting on September 12th, 2024, These two members protested that they viewed this rule as inappropriate, which I believe signals their intent to continue to violate. Demands for staff report or work products requiring well in excess of 15 minutes without approval of the council as a whole have been common. This diverts resources away from the agreed priorities of the council and the citizens of Lakeside in service of the personal agenda of the council member making such demands. Section 4 of council rules regards the placement of items on the agenda. 4.3, documents for the agenda shall be received by the city recorder manager no later than 4 p.m. 7 days, that's 1 week, prior to a monthly meeting. Only documents deemed urgent by the mayor, the city council, the city attorney, or the city manager may be added late to the agenda. One of the two disruptive council members requested adding an agenda item the afternoon of December 12th, 2024 meeting. The other requested an added agenda item late this afternoon for this meeting. Additionally, these two disruptive council members have been pushing hard for secret executive session meetings to hold hearings to see if our current city manager has committed an offense that would lead to termination, but have not revealed what these offenses may have been. This appears to me to be a deliberate effort to harass our new city manager into resigning. I had originally intended not to name the two disruptive council members, thinking that raising the issue would be sufficient. However, in light of their recent comportment, I doubt that that will be sufficient. Also, sunlight is the best disinfectant. I'm referring to Councilors Wood and Hand. As I stated earlier, I have reluctantly come to the conclusion that both of these councilors are deliberately seeking to destabilize your city government. This needs to stop. I have no reason to believe that asking Mr. Wood, Ms. Wood, or Mr. Hand to curtail their transgressions would have any effect. It is up to the citizens of Lakeside to insist that their council members work on their behalf rather than placing their own interests ahead of the interests of the public. I would encourage the city manager to refer council members exceeding their authority to take their issues up with the full council. Thank you.
Councilor Hand?
Certainly appreciate Councilor Ward's comments today, and in response to that, I would certainly say that any accusations that I personally have sought out the city manager's attention more than appropriate should be backed up with some sort of proof. I've had very few communications with the city manager since her time here, and I don't believe that's the case. I do have several things I would like to discuss with the full council. I've made requests to have special meetings to have those discussions in the light of day. Some of those discussions are required by law unless waived by the parties in question in executive session. It's not my choice to have them in executive session. That's what the law says. My original comments for tonight have to do with our election process, and I did intend to say a lot more about that, but as the mayor read, what it is for our current election cycle, and I very much encourage future council to continue this discussion so that there's no questions as to the process for future elections.
Okay, my comments. I absolutely agree with Councilor Ward's synopsis of the situation. I am sitting here with Krista's resignation notice, and I think the city and councilor members Wood and Adam Hand have both harassed her, bullied her, and that is unacceptable. I'm sorry, but that's what's been going on. And this is the situation you have now put the city in. The city will have no knowledge in this office. So what do? Okay, who's gonna put the documents together for the audit? Who? Nobody. So you just basically are sinking the city by your actions, and I don't appreciate it. Okay, Councilman Miller?
I will repeat what I said last meeting, and that is, people make mistakes. We have to work through them. We have to treat each other with respect. And we'll get a lot farther that way.
First thing I'd like to thank is Krista for what she's done so far for the city council and for the city of Lakeside itself. And second, when it comes to the Rainbow property, this has been going on way too long. We need to get this going. We need to have either face-to-face or we need to get these people together and make a decision because this has gone on way too long. I've talked to other people in the city of Lakeside and they agree with the same thing. It's just, we need to get this going and we need to get that cleaned up.
Councilor Wood?
In response to the egregious comments about bullying and harassment, I will gladly print out the maybe 6 emails I've sent to the city manager requesting agenda item corrections. And I may have requested the day before 7 days that we have July financials reviewed for council because they were voted on and approved, but not in our packet in July. That was my only agenda item I requested. Other than that, I would gladly print out all my emails for all the citizens to read. There was no bullying, there was no harassment. And between the executive session, yes, there's been certain things that the city manager has done that I think the council needs to discuss as a whole. And the bullying harassment thing, that is, those allegations are very, very serious. And I will not stand by the fact that I did that to the city manager. I went into her office multiple times and told her I would support her in all of her efforts to try to get police in our town. I told her I would go to Coos County meetings to support her in her efforts. I was not bullying her at any time, and that is absolutely outrageous. I will print out all my emails that I've ever sent to the city manager, and I will gladly post them for any citizen to read. At this time, that is all I have to say. I mean, I am fully transparent in my efforts to try to make this city better, and I have never once had a personal agenda that is not relevant to the city. The city is my main priority and always has been. It's just accountability, communication, and yeah, I'm done.
All right. I adjourn this meeting at 7:15. Meeting's over.
Well, I appreciate your comment, to be honest. I certainly don't believe that print out of the actual communication.